Afternoon, please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 01-23-00704-CV, Industrial Specialist LLC versus Blanchard Refinery Company LLC and Marathon Petroleum Company. Starting with counsel for appellant, please make your announcements.
Ron Kaplan on behalf of Industrial Specialists.
Very good.
Eric Badger also on behalf of Industrial Specialists.
Welcome.
MADDUX on behalf of Blanchard and Marathon along with Joel Montgomery and also me.
Very good, welcome. Do you wish to reserve any time for rebuttal?
5 minutes, John.
Very good. Just a couple housekeeping matters before we start. You all know this because you're experienced, but green light obviously means start. Yellow light, 1 minute left in your argument. Red light, stop. If you're in the middle of a question, when the red light goes on, please finish your question and then sit down. Also, we've read the briefs in the case. We're familiar with the facts. If both sides could just dive right into the legal arguments, because the 20 minutes will go by fast. And with that said, we're going to ask both sides if you could start off your argument today by discussing the applicability and application of the express negligence doctrine in the context of comparative indemnity. And with that, we're now ready to proceed and hear from counsel for appellant.
Thank you, Your Honor. The fundamental question in this case is, can Marathon settle claims for its own negligence, then force ISI to contribute to the settlement based on an agreement that expressly excludes indemnification for Marathon's own fault? And the court's correctly identified one of the key issues in that regard is the application of Ethel to this case. And to understand why Ethel applies in this context, I think it's necessary to frame the loss for which Marathon seeks indemnification. The loss for which they seek indemnification is their own voluntary settlement payments for claims of negligence against themselves. These are not vicarious liability claims on behalf of negligence of other parties. These are quote-unquote direct negligence claims against Marathon for their own fault. The loss is, top to bottom, a request for indemnification for Marathon's own fault. And so, while the claims ultimately arose from a fire,
is it Marathon's own fault or is it their concurrent fault?
Under the jury's findings, the cause of the fire was the concurrent fault of Marathon. But as a matter of law, the fault for the negligence claims is Marathon's own fault. And I think that kind of flows into the Jenkins argument, which is, as a matter of law, the only thing they could settle is their own negligence. But I think, the Supreme Court in a couple of other contexts, including interpreting the anti-indemnity statute, has said, we're not going to look past the face of the complaint and relitigate, the ultimate meta-level causes of the assertion of this claim for negligence. And so I think when you're looking at what the plaintiff sued Marathon for, it's the direct claim of negligence against Marathon for their own fault. And so when you're looking at the piece of the piece that Marathon actually settled in this case, that is 100% Marathon's fault. They didn't settle the universe of claims arising from the fire. And so I think when you actually delve down into what they did settle, the only things left is that it is Marathon's negligence. And so I don't really think it's a case of comparative indemnity. It's a case for indemnification for their own fault. That's the only thing they could as a matter of law settle, and that's what they did settle. And so you have in the trial court this apples and oranges comparison where Marathon gets two negligence findings on these negligence questions that are tied to the occurrence. And so what's the occurrence? The fire. But there's a potentially infinite number of claims that arise from the fire. You could have economic loss, you could have environmental contamination, you could have a whole bunch of other things. But again, the only narrow subset that the Marathon settled in this case wasn't even all of the personal injury plaintiff's claims. They expressly carved out ISI from their settlement. And so the only thing that is left to settle is Marathon's own fault. And so I think through and through, this is a case where Ethel applies, and the only way the plaintiffs try and evade that is, kind of through this legal gymnastics where they are mixing these apples and oranges. But I think at the end of the day, when the court actually looks at the faces of the complaint that are in the record as court exhibits, it's clear that Marathon's being sued for their own negligence. And that's where the analysis can really, frankly, start and stop.
So when Marathon settled or paid the underlying plaintiffs here the settlement, and then they went back to the other defendants and asked for reimbursement for part of that, is that correct?
I don't think structurally that's how it worked. I think they all contributed at the same time. So they were all at the negotiating table at the same time. And so yes, you did have 3 other contractors who contributed towards this global settlement. But under Jenkins, the only thing those parties could settle were their own claims. So their contributions purchased for themselves.
A contribution and indemnity are different things though, right?
Correct. I guess I should say contribution in a non-legal sense. So they put money towards the settlement, and the only thing they settled with those claims was they got a release for their own claims. And so I don't think they were contributing to Marathon per se. They were putting in money to obtain a release of the claims against them, and they all happened to go concurrently. There were 4 parties that all obtained releases. And so I think, Ethel applies, but even if it doesn't, there are a multitude of other legal bars in this case. I think you can start and stop with a couple of other points, and I think perhaps the simplest, I would like to address Jenkins at length and the text of the indemnification agreement, but I think the simplest one, and maybe the clearest path forward for the court, is the procedural default of Marathon in this case. Over ISI's objection, Marathon submitted this multi-million-dollar breach of contract claim on 2 wholly immaterial negligence submissions. And so they have waived any right to recover under breach of contract. And so when you look at Marathon's claims, they say, well, everything was conclusively established in the record. But that's just simply not true. Every single element of a breach of contract claim was in dispute in this case. And to start with...
So let me back up a little bit. So your position is on Ethel and the express negligence test that it doesn't apply here, or that it does apply?
Oh, I think Ethel clearly does apply. So my front line argument, just to clarify to the extent there's any confusion about the briefs, is the contract wholly excludes any indemnification for Marathon's negligence of any degree, joint, sole, concurrent, whatever it may be. So there is no Ethel problem when the contract was properly construed, because there is no indemnification for concurrent fault. But if the court views the contract as at least ambiguous on that question, then Ethel clearly does apply in that scenario. And the Supreme Court in Ethel and the subsequent cases said you can't satisfy the express negligence rule with an ambiguous provision. And so I think even if you kind of accept their reading of it, they still lose under Ethel because the contract language does not satisfy the express negligence test. They concede that much. And they just claim that it doesn't apply to comparative indemnities, but we've cited probably more than a dozen cases in our briefing that have applied it, or at least recognize that it should apply in those contexts.
What language would this indemnity provision need to comply with Ethel for comparative indemnity?
I mean, one, it would have to, I think it would have to do, there's 3 things that are really missing from it. I think the first is any reference to the negligence or concurrent negligence of Marathon. So there's no reference that Marathon will be indemnified for any negligence they have. So that's the first hurdle. But separately, there's no reference to any apportion. I think there would have to be a reference to some intent to apportion fault amongst the parties. And third, there would have to be some type of scheme to actually allocate or apportion the fault. And I think this case kind of lays bare the deficiencies in the contract, because none of those 3 things are possible. And so when you actually look at the history of this case, the first time Marathon ever even told us the amount of money they sought as indemnity was when they moved for entry of judgment at the end of a trial. You think surely if the parties intended for an allocation scheme to be workable, you would have some mechanism to resolve that allocation short of an entire trial on the merits, which is what was required here. And so none of those things are present in the agreement. And so certainly you could theoretically construct a comparative indemnification scheme in a contract, I think that would be, it'd be uncommon, to say the least. The most common type of indemnity that you see in virtually all contracts is an indemnification without regard to fault. And so you would just say, regardless of the cause of this occurrence, if your workers are injured, you're going to indemnify us even if we're negligent. And so that was the type of indemnification all the other contractors at Marathon's facility had, and ISI didn't. And so I think that, is telling that this is an atypical indemnity. And so Marathon and their amici, have pointed out, quite explicitly to the freedom to contract. But that principle really cuts against them in this case because they have a highly unusual one-off kind of indemnity provision when they could have negotiated a much more standard regardless of fault indemnity provision, and they intentionally didn't do so. And so you have Marathon here at the council table arguing for something they couldn't actually get at the bargaining table in their contract.
So what's your response? So they made the argument, the exception provision or the language at the end of the indemnity clause that says, except to the extent. So it provides for indemnification for anything having to do with work relating to the contract, performed by the contractor, y'all, or by reason of the contractor, except to the extent of the liability, damages, loss, attributable, or caused by the negligence of company, Marathon. How do you construe that language?
So I think taking them in two pieces, start with the except. It's unambiguously an exception. It's not a reduction. It doesn't say shall be reduced in proportion to. So it's a clear carve out, a clear exception is being called for. And then when you get to the three words, to the extent, that's a commonly used legal phrase that sets out a condition. It could be read as if or when or unless. And so it's articulating a condition. To the extent is just saying, to the extent Marathon has any negligence, you owe no indemnification. It doesn't contemplate any comparison of negligence. It's just saying, to the extent they have any negligence, no indemnification is owed. And so I think that's the only appropriate way to read that case. That's consistent with the Texas Supreme Court's reading of similar language in a number of cases that Marathon has relied upon, including Gulf Insurance. The only way Gulf Insurance got around the express negligence rule was by saying that to the extent language provides for no indemnification if the indemnity is in any way at fault. And so I think that's the proper reading. But if you're going to say, guys, you both have made good arguments, very good lawyers on both sides, we're really struggling with this, and we think it can be fairly read as the way ISI is reading it, and it could also be fairly read as the way Marathon's reading it. Marathon still loses in that circumstance because the provision's ambiguous, and one, didn't obtain any findings as to a meeting of the minds, so they didn't meet that first element of their breach of contract claim, so they've waived that factual finding, but separately under Ethel, they would have needed to satisfy the express negligence rule, and the ambiguity wouldn't do that.
And here the trial court in its 166G ruling,
yes,
it defined the terms liability, loss, or damage as the settlement or the settlement agreement. Is that correct?
Correct. Yes, she did do that, but the basis for that is very convoluted. Essentially,
has anyone contested that rule? I mean, contested that on appeal, or because as we look at this, how do we read this? We need to read it in light of that uncontested.
So I think you have to read that factual finding in light of the parties' dispute over compulsory obligations. And so I think these are the third sections of most of both sides' brief. And this is the issue of, would Marathon have been held more than 51% liable? And so what the court was saying was, it's a liability or loss because they face the prospect of being held jointly and severally liable. Therefore, they could have had a legal obligation to pay for claims of another entity. That's the only theory that has ever been articulated.
Or a contribution, right? Or what are you talking about?
Well, correct. It effectively, what they're saying is creating a contribution scheme by contract. And so that was what the court's finding really was saying, was that the parties agreed that if there was a prospect of being held jointly and severally liable, that would be an involuntary payment because they'd be legally obligated to pick up the share of some of those other parties. And so I think that was the context in which the trial court made that holding.
So is it a correct reading then of this, based on that 166G ruling, is it correct to read this except to the extent language as there's indemnification obligation except to the extent the settlement is attributable and caused by the negligence of Marathon?
Can you rephrase that? I guess I'm not
So
following.
there's an indemnification obligation owed by your client except to the extent, or you said unless, the settlement, which is the definition of liability, loss, or damage, according to that 166G, is attributable and caused by the negligence of the company. And so that would be the exception under your argument?
I think so, yes. I think the settlement is the liability or the loss that's at issue. So I do think you can read that into into the place of the liability, loss, or damage.
So caused by the negligence of the company, Marathon, how do we read the word the negligence?
I think you have to read it in light of its ordinary meaning, and you also have to read it in light of ethic. And so,
I mean, does the negligence mean any negligence?
it does, of any kind, character, or degree. It could have said the sole negligence, but even the sole negligence wouldn't be sufficient. That was the Singleton decision out of the Texas Supreme Court. I think if it had said the sole negligence of Marathon, you'd actually have a stronger argument for why indemnification was owed in this context, because it would at least contemplate that in that scenario there would be concurrent negligence of the parties, and you could infer an intent to indemnify on a comparative basis under that circumstance. But the Supreme Court in Singleton said specifically, you can't satisfy the express negligence rule by reference to the exception. And so I don't think there's any way around it, Your Honor.
Are there any further questions?
No. Further questions? No.
Thank you. We
Thank
appreciate
you.
your time is up. We appreciate your argument.
Thank you, Your Honor.
Now ready to hear from counsel for Appellate.
May it please the court, I was planning on focusing on two issues that I think go directly to your question. The first is whether the express negligence rule applies to an indemnity provision that cannot be read to create an extraordinary shifting of risk. And the second was whether Jenkins prevents a settling defendant from enforcing its bargain for contractual indemnity. And I think those two dovetail together because Jenkins is the reason that my opposing counsel says that we must have only settled our own negligence. Indemnity agreements like the one we have here are legislatively recognized and pretty common in the context of a subscribing employer who can't be sued. And they serve an important goal of employee safety and providing an incentive for the employer to act responsibly. Obviously, the express negligence rule serves an important goal as well. And that is to prevent parties from basically sneaking in a provision by which an indemnity is exculpated for its own negligence. And I think that's the question here, is whether that was done. And I think that the parties actually agree, when you get down to it, that nothing in this indemnity provision indicates that the parties intended to exculpate, I can't say that word, Marathon for its own negligence. And he is right that we could have, but that's not the bargain we were making. And for the court to come in and say that we had to do that, that wasn't the bargain that either party was making. The bargain that was being made is that Marathon would be indemnified except to the extent of its own negligence. And that takes the case, the provision, outside of the express negligence rule. And why? It all goes back to the extraordinary shifting of risk. Why is it an extraordinary shifting of risk for an indemnity to be exculpated for its own negligence.
Can we talk about that for a minute?
Yeah.
Because what is the difference between Marathon's own negligence as in its sole negligence and its own negligence when it's shared with somebody else in a concurrent sense, and how does that impact analysis?
I think that it goes just to what I was about to say. It has to do with the extraordinary shifting of risk and why it's an extraordinary shifting of risk. If I am an indemnity and I know that I'm not going to be held liable for my own negligence, that creates a disincentive to act with ordinary care. And this is what tort law is all about, right? And so it's an extraordinary shifting of risk, and we're not going to hold that an indemnitor is liable for that without a indemnitor knowing that it got into that. It has to be expressed under EPPELLANT. But in this case, regardless of the percentage and how negligent Marathon was, it was not trying to be exculpated for that. It was willing to be responsible for its own negligence, but not anything above that.
And so how do you read the word "the"? So I'm going to ask the same question I asked your counsel. So the language that we're talking about, except to the extent, so there's an indemnification obligation, except to the extent the liability, loss, or damage, which the court below said was settlement. The settlement is attributable and caused by the negligence of Marathon. So how do you read, so two parts, except to the extent, you don't read that as the word unless. There's an indemnification obligation unless. You read those first four words as what?
Except to the extent, except to the degree of. If it meant unless, first of all, I think the parties would have said unless. But secondly, if it means unless, then that means that what their position is.
So you read it as an expansion or a limitation on the preceding phrases of obligation? So there's an obligation in the preceding
It's a
clause.
limitation, yes. I think I understand.
You read it
what
as a
that-
limitation also?
Of what part? I'm sorry.
So we're talking about the except to the extent language.
Yeah.
So there's an obligation defined above in
Yes.
lots of sentences.
Yes.
And then in your view, is the clause that begins except to the extent a limitation or a broadening of the preceding obligation?
It's a limitation in the sense that here's the overall indemnity,
Right.
and then whatever extent is attributable and caused by Marathon is carved out. That's exactly what happened in this case. Is we carved that percentage out and did not seek that percentage.
So your argument is that this carves out any indemnification obligation with respect to Marathon's own negligence.
Correct.
Right? And so then we get to the word, the phrase, or the words, the negligence. Does the negligence mean any negligence, sole negligence? I mean, your argument seems to be, as I understand it, the phrase, the negligence is sole negligence or separate negligence.
I think separate would be more correct. I mean, there are a lot of cases, as opposing counsel mentioned, that are sole negligence cases, that the express negligence rule does apply. And if you look at those, the reason is, and actually all of these express negligence rule cases, what the courts look at in those cases is, could this contract, this indemnity provision, be read to provide indemnity for the indemnity's negligence? So a sole negligence is actually in the express negligence rule, because the argument there that the courts have used is, well, it was limited to sole negligence, so any other negligence, concurrent negligence or whatever, could conceivably implicitly be within the provision, and you can't have an implicit provision. This is not an implicit provision. We agree that it's any negligence of Marathon, but it's the extent of Marathon's negligence that's carved out. It's not, if it means unless.
So you agree it means any negligence, except your interpretation of the words except to the extent then limit that any negligence to a subset?
The extent of our negligence is what is carved out.
The extent of your any negligence is carved out.
Yeah, and I mean, negligence,
So then you wouldn't be indemnified for any negligence? Is that, am I understanding your argument?
we would not be, we have, throughout this case and in the judgment, we have never sought indemnity for our percentage of negligence.
For any negligence?
Any of our negligence, if it's attributable to and caused by Marathon.
So would any negligence include your concurrent negligence or comparative negligence?
That's attributable to and caused by Marathon, yes. And I want to point out that if the cause instead means unless, then this is the situation we have here. If a party settles, there's no indemnity, because that's their position under Beach v. Jenkins. Once you've settled, you can't enforce indemnity. And if
Does Beach say that?
no, and I would like to get to that, but I do want to say that the rest of their position is, if we are negligent at all, even 1%, there's no indemnity. So the only way that there would be indemnity under this provision is if we had no liability at all.
But the jury below found 38%.
Correct. But what I'm saying is, we don't construe an indemnity clause to have no effect. There's no situation under which there would be indemnity under their reading that it means unless we were at all negligent. Now, as to your question on Beach, no, it does not say that. Beach is limited to the contribution context, and it's been around for 40 years now. No one has ever applied it in an indemnity context. And in fact, there have been several cases, an equitable subrogation case, which has been a truck, and a contractual, reserving contractual rights after a settlement with the Southwestern Bell case, where the court said, these are not the same policy considerations. We're not going to apply Beach v. Jenkins. Also, 3 cases that are cited in the briefs, most if not all of them by the other side, the Danishu case, I'm probably pronouncing that incorrectly, the Herzog case and the Paragon case, where the courts talked about Beach in the contribution context. And then they had another section where they talked about indemnity. And they decided indemnity on different grounds. They didn't even talk about Beach. They decided indemnity, 2 of them on express negligence rule, and the other one was, there was no contract.
Is there a scenario where a party in the shoes of Marathon in this case could settle, all the plaintiff's claims against everybody and then move for contractual indemnity under the party's indemnity agreement? Or would Beach prohibit that?
No, that's, yes, I think, I understand your question.
So can a party, can one defendant settle all the plaintiff's claims against, if there's a lawsuit with multiple defendants, can one defendant settle all the liability claims against all the defendants, and then move for indemnity under an indemnity agreement with one of the other defendants? Does Beach prohibit that, or does Ethel allow that?
So I don't think Ethel really goes to that. Beach does not apply to an indemnity claim. It's never been applied to an indemnity claim. So yes, I think that's essentially, unless I'm missing something in your question, what happened here is that we settled and then sought indemnity from ISI. ISI was at the mediation, but refused to settle, which, if the answer is that a party can never settle and instead has to go through an entire trial, that is what is going to cause the satellite and additional litigation. It can't be the case that we are not going to allow parties to settle cases, because doing so would prevent your ability to come back and seek indemnity, because the indemnitor simply has to do what ISI did here, which is sit back and say, no, wait to see what's going to happen. And they're not even bound. They were just a responsible third party. They're not even bound if they don't like the result of the trial. And so this is going to cause, you know, a lot of additional litigation. I mean, I think that's why we have an amicus brief here in the Court of Appeals, because these agreements are not unusual at all. I do want to point out.
Let me ask you a quick question,
yes.
just to make sure I understand. So in the judgment, there was the settlement payment was 104 million. Is that right? And
That's
then,
right.
And then there was the $86 million. And then there's, so what does the $86 million represent?
That's what Marathon paid.
That's what Marathon paid out of the 104. And then out of that 86, the judgment was against the indemnitors here for 46, right?
So right, you take the percentage.
And that was minus the 38%, right?
Yes, exactly. Yes. And I noticed we have a typo in our brief at one point. It is 104 million. I noticed that this morning. I did want to point out on the to the extent language that there are some cases on that. The Honeywell case, the Altman's case, the Tri-State case, the Vaughn case. The Vaughn case is not an Ethel case. It's a federal case, but it's the same principle. It's just not the express negligence rule. It's this U.S. v. Schleckinger that all talk about to the extent, meaning, you know, determining the extent of one party's negligence in a proportional responsibility type argument. And before my time is up, I want to make sure that I've fully answered the court's initial question, and I want to go back to Ethel and the idea of Ethel applying to a concurrent negligence situation. So I think it's important to look at Ethel. The indemnity clause in Ethel basically said that the contractor shall indemnify the indemnity, the owner, against any loss as a result of operations throwing out the performance of the contract and caused by the negligence of the contractor, so the indemnitor or its employees or subcontractors. So the clause said, or caused by the indemnitor. But Ethel, the indemnity, came back and tried to say, well, it also says any loss. And any loss means it covers my indemnity either. And we sit here in 2025 and we all say, well, of course it doesn't. But this was pre-express negligence rule. And so that's what the court was looking at. And so the court said, you know, any loss is not broad enough to include the negligence. We're going to adopt the express negligence rule. And then it went on to say, because Ethel came back and said, well, can we at least get 10%? Because that's what Daniel had been found liable for. And the court said, well, this is not a comparative negligence provision, a concurrent, and it's obviously not. It's very broad.
Right.
And then it said, indemnities seeking indemnity for the consequences of their own negligence, which proximately cause an injury jointly and concurrently with the indemnitor's negligence, must also meet the express negligence test. The important part of that is that the indemnity be seeking indemnity for the consequences of its own negligence, which is not what we have here.
Well, hang on. I actually think it's fairly important that it says proximately causes injury concurrently with the indemnitor's negligence. So it looks to me like under Ethel that concurrent negligence isn't something that you can split into just Marathon's negligence and avoid the application of the express negligence rule.
Well, I think if you look at why Ethel is decided, you absolutely can.
Okay.
Because the whole purpose is not to allow an extraordinary shifting of risk. And there is no extraordinary shifting of risk here.
So when you look at Ethel, as I read Ethel, the express negligence test applies to concurrent or comparative negligence as well. Do you take a different reading of that?
If you're seeking indemnity for your own negligence.
And so if you're seeking comparative indemnity for concurrent negligence, you're saying Ethel doesn't apply to that?
If you are seeking, so if you look at all the cases underneath.
Because you were
Ethel,
found concurrently negligent here, right? I mean, you were in the trial below.
we were found
you were-
38% negligent,
Right,
yes.
concurrently and then
But,
comparatively.
I mean, it's well established that we can proportion out negligence
But how do we know that from the contract language?
to the extent. I've just cited the cases that talk about how to the extent means the degree of, the proportion of. It's the extent that we were negligent. We are not seeking that.
Do you believe that Marathon was concurrently negligent in this case, or are you saying there really was no concurrent negligent because it was simply proportionally negligence?
Well, we are proportionately we were 38% negligent. We are not contesting that. If that's
But are you saying that you weren't concurrently negligent at all?
concurrent negligence just means that I mean, there's one injury.
Yeah.
Right.
And you divide out who caused it.
I guess what I'm struggling with is the language again in Ethel that says the word concurrently, and I'm not sure how to square your reading with the word concurrently with the indemnitor's negligence in the case law, even though you might have a rationale for why I could read it differently.
I think it's the seeking indemnity for the consequences of their own negligence language. And in fact, if you look at, I think it's the AIG specialty case that sort of looks at Burns and Gulf Insurance Burns and Ethel and says, well, here's how you read those together. It has to be that you are trying to get out of your own negligence, and we never did that in this case. And yes, opposing counsel is right that we could have, but why would the court make us have an agreement that we never intended to enter into? No one ever intended to be responsible for Marathon's negligence except Marathon. But we settled more than our proportionate share, and we are entitled to go back and get that under indemnity.
Which is, the more than your proportionate share would be the concurrent negligence, all right?
It's the other party's negligence.
Right, exactly.
Yeah.
Okay. Any further questions? No. Any further questions? We appreciate your argument. Thank you very much, counsel. We're now ready to hear rebuttal argument.
I'd like to start where we left off, because Marathon contended that they had settled more than their proportionate share of the responsibility. Where is that factual finding in the record? The trial court didn't make it on Rule 166. The jury didn't make it at the trial court level. And the reason was because the only question they submitted was, what's the cause of the fire? Why didn't Marathon want to submit the question of, did Marathon pay more than its fair share of the settlement? We specifically objected and tendered that question, and they refused to allow the jury to answer it because the jury logically would have said they paid their fair share. Their own experts said the damages they were facing were $200 to $300 million. What's 38% of $200 to $300 million? Roughly the amount they contributed to the settlement. So if you actually submitted the question to the jury in a reasonable way that the jury could have understood what the issues were being submitted to them, they surely would have answered against Marathon. And so the only reason we're in this predicament on appeal arguing about did they pay their fair share, did they not pay their fair share, is because they refused to submit that to the jury to have them answer affirmatively against them, because they knew that would be a prohibitive bar to pursuing this case on appeal. And so I think that dovetails in, that's the factual findings point that we raised, but I think that also dovetails in with Jenkins. Whether you want to say, I think Jenkins establishes a common sense rule. You're presumed to settle the claims against you with your own money. Nothing more, nothing less. Whether that's a conclusive presumption that can't be rebutted as a matter of law, I think that's what Jenkins says. But even if you treat this as some kind of rebuttable presumption where that's the starting point, you're assumed to have only paid your fair share, and you could theoretically settle additional claims beyond your proportionate responsibility. They never obtained any of those factual findings to support that. And so regardless of how you view Jenkins as a legal presumption that's unrefutable and irrebuttable, there's nothing that allows this court to get outside of Jenkins. The second and third points I would like to raise. The first one is the proper construction of the agreement. Marathon effectively says, well, ISI's construction of the exception renders the provision nugatory. It essentially means nothing. We get no indemnification for anything. The problem with that is it provides indemnification for vicarious liability claims. If they're sued and it's attributable to our negligence on a vicarious theory, they're entitled to indemnification to that extent. And I think the court need look no further that the provision, our reading of it doesn't render the provision meaningless. You can look at Fireman's Fund, which is the case they primarily hang their hat on. What happened in Fireman's Fund? GM was sued kind of on a frivolous ground. They incurred $8,000 in legal fees, and they kind of threw up their hands and entered into a nuisance settlement for $20,000. They subsequently went and had an indemnity fight, and in that trial, GM was found to have 0% fault. And so what did the Supreme Court say? Is, yeah, if you're not at fault, you can get indemnification. And so I don't think that our reading of it renders the provision meaningless. It just has a limited scope as the parties intended. And so this brings me to my...
So let me ask you, so if the language of the contract, and going back to the except language, so except to the extent language, let me ask you this question instead. Is it your view that what they're asking for is comparative indemnity?
Yeah, I think quite clear. That's what they're seeking.
And where in this language would we find that? Your obligation to do that?
Nowhere, and that's why I think the court asked to start with Ethel, but I really think the discussion where I planned to start was with just a plain text of the provision. I don't think this provision...
Because if we're just looking at the plain language of the contract, and if this is a contract construction case, basically, each doesn't make any difference, does it?
I don't think it does. I think you could just read the face of the contract and say it doesn't apply if Marathon has any negligence. And the jury found, and they don't dispute, they're negligent. No indemnities owed. And you can end the opinion there. I think all of the arguments...
If we agree with you on that, I'm not saying that we do, but if we did, would we need to address any of the other issues?
I don't think so. And so well, I only have 11 seconds, so I won't even start that last point. But we respectfully request the court to reverse the trial court's judgment and render judgment in ISI's favor.
Any further questions? We appreciate your argument. Thank you very much. We want to thank both sides today for your argument and your briefing. It was excellent. With that, this case is submitted, and we are adjourned. Thank you all.
Thank you.